Hi, my name is Marc Fitapelli. I'm an attorney and the owner of MDF Law, a national law firm with offices in New York and California. I'm here today to talk to consumers who may have lost money as a result of their broker or financial advisor's negligence or malfeasance. If you're watching this video, it's probably because we have a blog or article on our website about your broker or financial advisor. And you may have questions about this information. You may want to know how we gathered it, whether or not that information applies to you, and if it does apply to you, what you could do about it. Could you sue? Could you recover any of your lost money? I'm going to cover all of that in this video, but before I get to that, I just want to give you a brief background about who I am and about my law firm. So, like I said in the introduction, I'm an attorney. I exclusively represent victims of financial injury. So my typical clients are people who are victims of Ponzi schemes, people who have been scammed, people who may have had money stolen from them, or people who may have invested in an investment based on false promises or based on omissions. I only represent consumers or people who've suffered financial injuries. I don't represent any banks, any insurance companies, and I haven't for at least the last 15 plus years. Over the course of my career, I've recovered hundreds of millions of dollars for consumers. Before I was a plaintiff's lawyer, I worked for two large national law firms. Now I'm in practice, and I've owned my own law firm since 2011. I work in New York City, and I have a partner, Jeffrey Saxon, and Mr. Saxon works in our office in California. And if you have any questions about any of the information that's on our website or this video, you can call our 800 number and you could ask to speak with me or Mr. Saxon, and you could ask to have a telephone or Zoom consultation, and either one of us will be happy to speak with you. So with that being said, I want to talk with you now about the information that's on our website and more specifically the blog about your broker. So I want you to understand two important things about that blog. The first thing I want you to understand is that it's attorney advertising and that it's based on public disclosures. And what our law firm does is we go through and we look for public disclosures made by the Securities and Exchange Commission, made by FINRA, made by the various state securities regulators. And what we do with that information is we try to identify brokers or financial advisors who we think may have significant customer issues. And these may be people who've been terminated, these may be people who have significant customer complaints, or these may be people who are under various regulatory sanctions or various regulatory investigations. And so we post articles about them. The information in the articles, none of it is based on our case file. None of it's based on cases we've settled, confidential information. It's all based on public disclosures. The second thing that I want you to understand is that some of the information is based on allegations, right? And so what that means is that it's based on allegations by customers, by securities regulators, or by brokerage firms or other brokers. And those allegations need to work their way through the court system or work their way through arbitration before they're proven. So that's what I want you to understand, is that this is attorney advertising. The information comes from public disclosures, and a lot of the information is based on allegations that still need to be proven. Okay. So now you may be asking yourself, if this information applies to you, what your immediate next step should be. And first and foremost, what you should do is you should contact an experienced attorney like me or my partner, Mr. Saxon, to understand what your legal rights are. You shouldn't look on the internet. You shouldn't look up videos on YouTube. You shouldn't read blogs or articles. You should actually speak to an attorney to understand what your legal rights are. You should speak to someone who practices in this area and someone who has experience in this area and someone who knows what they're talking about. So with that being said, I'll talk with you about our basic case and the basic case against your broker or financial advisor. And our basic case is a negligence case. And what we argue in almost all of our cases is that the broker or financial advisor deviated from some standard of care. And what that means is that your broker or your financial advisor did something to you that was different than any other broker or financial advisor would have done, right? That may be that they recommended an investment to you that lost a lot of money. Maybe they recommended a covered call strategy, or maybe they recommended that you concentrate your investments into one particular asset class like energy or technology stocks. Maybe they recommended a private investment to you, a private placement, or an obscure investment, an investment that has high commissions or high fees. The point is that their conduct likely deviated from what all the other brokers on Wall Street are doing. And the measure of that, the way that you as a consumer can measure that, is you go and you look at your portfolio and you look at the S&P and you compare whatever you're invested in. If it's not stocks and bonds, if it's REITs, if it's private placements, if it's annuities, you look at the S&P and you look at what you invested in and you compare the difference, right? And that'll give you some basic benchmark about how far you deviated from the standard of care, right? Because we use the S&P basically as the benchmark for what, as attorneys, we call it a well-managed portfolio. So that's your benchmark for damages or for the standard of care. It gets a lot more complicated than that in some of our cases, because a lot of our cases also deal with very technical violations. And sometimes we have cases that deal with technical violations of securities regulations or technical violations of the Securities Act, but it's all the same thing. It's all negligence, right? The regulations give us the standard of care. The regulations say, broker, you have to recommend, for example, suitable investments. There's a regulation called suitability regulations, called Regulation BI, Regulation Best Interest. And what that regulation says is it says brokers have to recommend investments that are in their client's best interest and that are suitable for them in light of their ages, in light of their risk tolerance, in light of their net worth, in light of all of these very personalized factors. And so that's the other thing that we look at when a new client contacts our office. We go through your financial background because it's very relevant for one of these cases. Because when a broker recommends an investment to you or an investment strategy to you, it has to be consistent with those things, right? If you checked off on the box that you're a conservative investor, they have to deliver conservative investments to you, right? If you're 70 years old, you should be getting conservative investments regardless of what you check off on the box. And they should be guiding you and telling you those things because they're your fiduciary and they're there because their knowledge of the markets and their knowledge of the securities is greater than yours. And that's the reason why you're paying them. And that's the reason why when things go wrong, you should call someone like me to sue them or at least figure out if you have a viable case against them. And, that's a good place to end. If you want to understand if you have a good viable case against your broker or financial advisor, call me or call Mr. Saxon, and we're happy to evaluate your claim. If we take your case, we do it on contingency. What that means is clients don't pay us anything unless we're successful on their behalf, unless we successfully recover money.